prepared to elect to stand upon their submissions and call no further evidence in the case, notwithstanding that the chamber may not sustain their no-case submissions. That is, the reason for that is in order to ensure that the particular standard of proof beyond reasonable doubt will be the standard that must guide the assessment at this particular stage. Now, if the defense have not thought about this, they may take their time and think about it and give us their answers, as I said earlier, when it is their turn to make oral submissions tomorrow and the day after, in any event, before our close of proceedings on Friday. The reason for this inquiry is this. To begin with, the inquiry, as indicated earlier, follows from the defense urge upon the chamber to assess the sufficiency of the evidence according to the standard of proof beyond reasonable doubt. But furthermore, barring a fishing expedition aimed merely at ascertaining what judges think of the prosecution case at halftime, a well-founded motion of no case to answer when made by experienced counsel in good faith for its own purposes may have even a stronger value as submissions for acquittal in any event. That is to say, a stronger value as argument of acquittal in the regular run of the proceedings, as if the defense have, in fact, opened and closed their cases, whether or not they called any evidence. That being the case, the experienced defense counsel with the right argument may see little forensic advantage for their case in calling extensive or any evidence at all, if indeed they have made a well-founded submission of no case to answer, since any evidence they call may be used against them. It is for that reason that the defense counsel who make a well-founded no case motion in good faith may see no difficulty with the idea of standing on their submissions and offering to call little or no evidence. Such a move does not result in an inference of weakness. It amounts, as the popular expression goes, to, quote, putting the prosecution to the strictest proof of their case. But this is something to be considered with the greatest care, for such a move can just be just as hazardous to the defense if they fail to call evidence when the circumstances of the case, when correctly appreciated, really recommend that the defense should call evidence. The procedure of offering to stand on the submissions of no case used to be a regular feature of no case litigation in some common law jurisdiction, and it remains so in others. In the past, for instance, in criminal cases, it used to be the practice in England that judges had the discretion to require that offer as a precondition to hearing a no-case submission. It may no longer be the case in criminal procedure there, but my understanding that it remains the case in civil cases. But in Australia, the practice persists in the voluntary manner of what is called, quote, the second limb submission, unquote. The second limb expression, as used in that jurisdiction, derived its usage from the default consideration described by the High Court of Australia in the case of May versus O'Sullivan. It follows from the following observations made by the High Court of Australia in that case. Quote, a magistrate who has decided that there is a case to answer may quite consistently, if no evidence is called for the defense, refuse to convict on the evidence for the prosecution. The prosecution may have made a prima facie case, but it does not follow that in the absence of a satisfactory answer, the defendant should be convicted, unquote. That observation follows the court's earlier pronouncement as follows. I quote again, when at the close of the case for the prosecution, a submission is made that there is no case to answer, the question to be decided is not whether, on the evidence as it stands, he could lawfully be convicted. I take that again. The question to be decided is not whether, on the evidence as it stands, the defendant ought to be convicted, but whether, on the evidence as it stands, he could lawfully be convicted. This is really a question of law. Unless there is some special statutory provision on the subject, a ruling that there is a case to answer has no effect whatever on the onus of proof which rests on the prosecution from beginning to end. After the prosecution has adduced sufficient evidence to support such proof of the issue, the defendant may or may not call evidence. Whether he does or not, the question to be decided in the end by the tribunal is whether, on the whole of the evidence before it, it is satisfied beyond reasonable doubt that the defendant is guilty. That is a question of fact, unquote. Now, we are not requiring the defense to elect to stand on their no-case submissions as a precondition to our consideration of their motions. We are now only inquiring of them whether it is an election they may consider and make, because that may have an effect on the proceedings from here going forward. So the prosecution would have then to clearly indicate or be understood clearly to have addressed in a comprehensive way the question whether they have proved their case beyond reasonable doubt. And the chamber may have to make the appropriate finding definitively according to that standard, as opposed to merely at the standard of prima facie. The prosecution may thus have to be given an opportunity to file a supplementary brief to address that second limb argument in writing, if it is the case that their written submissions already filed and their oral submissions today will not already have addressed that question specifically or adequately in their view. Proceeding in that way would require the Chamber's judgment to be addressed, if need be, in the two limbs broached in May and O'Sullivan, the first limb being whether there is a case to answer on the basis of the evidence as it stands, and the second limb being, if the answer to that question in the first limb is yes, the second limb involves our judgment as to whether the evidence as it stands satisfies the requirement of proof beyond reasonable doubt. As said earlier, if the defense have not thought about this, they can take their time and think about it and give us their answers when it is their turn to make oral submissions tomorrow and the day after.